Good afternoon. It's my pleasure to welcome you to the 16th Annual Wallace Stegner Center Young Scholar presentation. I'm Bob Kiter, the director of the Wallace Stegner Center for Land Resources and the Environment at the University of Utah S.J. Quinney College of Law. While we regret that due to the COVID-19 situation that we can't gather in person today, as we usually do for this lecture, we are grateful that we're still able to proceed through Zoom with the cooperation of our technical staff here at the College of Law, as well as our speaker, Professor Karen Bradshaw. Before I get started with a few announcements, let me acknowledge that today is Veterans Day, and we'd like to recognize those who have served in our armed forces, who have sacrificed, and who also currently serve in our armed forces defending our nation. We are most grateful to you for your service. This is the last program for this semester through the noon green bag and other presentations for the Stegner Center. But next semester, we have a robust schedule that cover a variety of different topics. Those include rebisoning the West, using executive fiat for conservation or destruction, from Roosevelt to Trump. Maybe we could add to Biden at this point. And also Vision and Place, John Wesley Powell and Reimagining the Colorado River Basin. Calendar of these events with the dates and the speakers and other details is available online at the Wallace Stegner Center website. I also wanted to note that March 25th and 26th of 2021, we will host our 26th annual symposium on the plastics paradox, societal boon or environmental bane. Registration is required for this event, and we'll have an agenda with speakers posted on the Stegner Center website right after the first of the year. The Young Scholar Program at the Wallace Stegner Center was founded in 2005 with the goal of recognizing and establishing a relationship with promising scholars early in their academic careers. Recipients are selected based upon their accomplishments, the quality of their academic work, and their promise in the field of environmental and natural resources, law, and policy. And I should add that our speaker today fits those criteria to a T. Let me also thank our donor for the Young Scholar Program. It's supported by the Cultural Vision Fund, which is actually the founding donor for the Young Scholar Program. The Cultural Vision Fund also provides support for other Stegner Center programs, including our symposium, our periodic conferences, and our lecture series. We are most thankful to the Cultural Vision Fund for their support. Were we in person, I would ask you to join me in thanking the Cultural Vision Fund for their support. Today, we will hear on the topic of wildlife as property owners. Rather than me describing the topic, let me simply introduce our speaker so we can move forward. Karen Bradshaw is a professor of law and the Mary Sigler Fellow at the Sandra Day O'Connor College of Law at Arizona State University. She's also a faculty affiliate scholar at New York University's School of Law, Classical Liberal Institute, and a senior sustainability scientist at the Global Institute of Sustainability at Arizona State University. Professor Bradshaw has published over 20 academic articles, several of which have received national recognition as being among the top articles of the year in the fields of environmental law, administrative law, land use law, and natural resources law. In addition, she is the author of the book that her talk today is based upon, Wildlife as Property Owners, a New Conception of Animal Rights. She's also the contributing co-editor of Wildfire Policy, Law, and Economic Perspectives. She graduated with a Juris Doctor with honors from the University of Chicago Law School, where she also served as a law review editor. She clerked for Judge Grady Jolly of the Fifth Circuit, spent 2 years as a research fellow at NYU's School of Law. And prior to law school, she earned a master's in business administration from Cal State University Chico and a Bachelor of Science in business administration from the University of California at Berkeley. In addition, she is the co-founder of The Aggregate, which connects women to women who are in the field of law. I should finally note that Professor Bradshaw's book, Wildlife as Property Owners, is available to order from the King's English Bookshop, which has consistently supported the Stegner Center programs as a bookseller, both for the events this year and in past years. With that, let me give you Professor Karen Bradshaw, who joins us from Arizona. And we're very pleased to have you with us today, Karen. We look forward to your talk on wildlife as property owners. Thank you for joining us.
Thank you, Bob. I'm honored to be here. And as you know, but everyone else should as well, Bob is, of course, one of my heroes in the field of natural resources and has been a longtime mentor and leader in the field. So to hear that introduction from him and to be selected for this honor is tremendous. I'm humbled and I'm very grateful. I'm grateful as well for Robin Kundis-Craig, another amazing scholar at University of Utah, who is also a friend and mentor, and to Jan Nystrom, Crystal, and Spencer, who've been tremendous, really, really top-notch in helping to put together this program. I'm also thankful to the Cultural Vision Fund. I'm tremendously, tremendously thankful for this award and for their ongoing support of it for 16 years. That's really quite phenomenal. And also to the editors of the Utah Law Review, who I've worked with to publish an article in connection with this talk today. As Bob said, the King's English Bookshop has a copy of my book, which I'll be discussing the concept of today, Wildlife as Property Owners, which is out. It's available for pre-order now. And I have sent signed book plates to the King's English. So although I'm not able to sign in person, my understanding is that any books that are pre-ordered from the King's English Bookshop will receive a book plate along with the book. So feel free to pre-order it from that or any other bookstore, but we're tremendously thankful to the King's English. They've been great to work with for this event. Finally, I want to join Bob in thanking the veterans. Today is Veterans Day, and I, like so many, have a number of veterans and active duty military personnel, who are important in my life. And of course, veterans and soldiers are important in all of our lives. So thank you, and a moment of recognition for these leaders in our country who are fighting in many ways at home and abroad to support this country. With that, I am excited to share with you today the idea of wildlife as property owners. This book and this concept are in response to biodiversity loss. And as I'll describe in a bit, I truly, genuinely believe that biodiversity loss is the most pressing environmental issue that we have today. It is also silent, it's hidden, it's unseen, and it lacks the drama and the moments of flash attention that are so commonly associated with other very important environmental issues such as climate change and the related events that occur with that, along with pollution, oil spills, and other sort of triggering events or visible things that show us that there's a problem happening in the natural world. But biodiversity loss is a crisis of somewhat epic proportions that we have yet to fully understand. So just to give some statistics for why I'm saying that, and then I'll sort of tell you where we're going with the solution I'm presenting today. But I want to situate the problem, because I find that with biodiversity loss, which is the loss of plant and animal species, there's one of two responses. Generally, people are either very outdoorsy and connected with nature and are therefore constantly seeing wildlife, or people are in more urban climates, see wildlife less often, and yet fail to understand the need for biodiversity and ecosystems. And so there are two kinds of dynamics here, both of which contribute to a lessened understanding of the urgency of biodiversity loss. And as someone who splits my time between a very rural former mill town of 1,200 people at the base of Mount Shasta, California, where my family's lived for 4 generations, and also lives in the suburbs of the 6th largest city in the United States, Phoenix, I personally encounter both of these phenomena in different ways. But when I read the statistics and learned the statistics behind biodiversity loss, it was quite striking. So I'll share those with you now. A World Wildlife Fund assessment shows an average decline of 60% in population of vertebrates globally between 1970 and 2019. So a 60% decline in that period. Only 4% of Earth's mammals are wildlife as measured by biomass or weight. Human and human-owned livestock make up 96% of the biomass of mammals on this planet today. A May 2019 report from the United Nations suggests that 1 in 6 existing wildlife species may be endangered by 2050. This is perhaps commonly known now from a television show called The Tiger King, but more tigers live in backyards in the United States today than in the wild worldwide, right? A shocking statistic there. And 30% of the non-ice surface of the Earth is used to raise livestock, which of course is a competing resource user with some wildlife species in ways that we can address later in the talk. But collectively, these statistics paint a picture that is increasingly coming onto an international stage as a crisis situation, right? Elizabeth Kolbert wrote this book, The Sixth Extinction, that describes meticulously an overview of the scientific literature and understandings that are collectively showing that biodiversity loss is the hugest threat to humankind today. And there is a growing awareness with her best-selling book, along with the work of E.O. Wilson, who recently released Half Earth, which proposes setting aside massive amounts of land for animals to avoid this widespread catastrophic extinction, that collectively show an increased awareness of the extent to which biodiversity loss, or the loss of plants and wildlife, is putting humankind at risk. And so this is really the anthropocentric concern about wildlife, why people who are not generally as attuned to environmental issues may care very, very deeply about biodiversity loss. So to take it out of academic terms and put it in plain English, if animals and plants continue to die at the rate that they're dying, we will die too. Because of ecosystem science, we understand what indigenous peoples and rural peoples have understood for generation, if not millennia, which is that we as humans are interconnected to every other living thing. And much like a game of Jenga, where you can take out one block here and one block there, and the thing looks okay and it's still standing, eventually when you take a piece out and it's impossible to know which, the entire tower collapses. And that's a bit what ecosystems are like. They call it trophic collapse. That's the scientific term for when you take out enough members of species, enough species from an ecosystem, that the collapse occurs. And when you have ecosystem collapse, that's widespread, catastrophic loss within the ecosystem of all of the animals, not just those that were considered at risk previously, but the entire ecosystem as a whole. And what scientists are warning is that humankind are at tremendous risk because of the biodiversity loss of the surrounding species. So that's the risk, that's the problem, that's what I'm here to talk about and thinking about. What solutions do we as lawyers have for this? And the answer, since roughly 1970, has been federal statutes. So the most notable federal statute is the Endangered Species Act. It's important, but it is also flawed in ways that we didn't understand at the time that it was enacted. And it's ultimately ineffective alone or in a vacuum to try to solve this problem. And the reason it's ineffective, I argue, is because it doesn't get to the true root of the cause of biodiversity loss, which is habitat. Essentially, humans and other living creatures are in a competition for competing resources. And you see this underlying virtually every dispute surrounding natural resources, wildlife uses, and we frame it in so many ways, but in virtually every environmental dispute I can think of, ranging from the Sagebrush Rebellion to the spotted owl situation in the Pacific Northwest in the 1990s, the recurring trend is that you have humans competing with other species for a resource. For example, wildlife, including wild horses, are competing for forage on the range with cattlemen, ranchers, and graziers. You have spotted owls competing for virgin timber habitat with foresters who are seeking to cut down the trees. And these dynamics are repeated again and again throughout the West. But when we frame them in ideological or politicized terms as urban versus rural or environmentalist versus rural land or resource uses, we're missing the root of the problem, which is that we are a species that competes not only with one another, but also with other living species for land and resources. And until we acknowledge this resource-based, this property-based problem to biodiversity loss, to the reason that animals are decreasingly available at the rates that they were, to the reason why species are dying, it is impossible, in my view, to solve the problem. Although the Endangered Species Act tries, it fails for a variety of reasons, the number one reason of which is that it fails to provide a viable property solution to this habitat-based problem, and so has suffered tremendously in the court of public opinion and related funding measures over time, such that the Fish and Wildlife Service has been essentially stripped of its requirement, its statutory mandate, to undertake critical habitat designation. And so in some cases, you have situations where endangered species are saved in the sense that they still exist, but they're in fact living in cages in the back of the zoo with no wild to return to. Now, I will say that sometimes when we begin to talk about biodiversity and animals and biodiversity loss, it very quickly becomes polarized because people equate biodiversity with animal law. And I'll describe later in this talk how those ideas differ, but I really want to say the idea of giving wildlife property rights is bipartisan. It is something that the cattle ranchers or the foresters or hunters can agree with just as much as the environmental advocates who are encouraging species preservation already. And the reason why is it simply relies on this age-old, pre-existing thing we have in law, an institution that's been around since the beginning of legal time, which is property, right? And the idea of wildlife as property owners is to simply fold wildlife into our system of property. And I will admit, it sounds a bit crazy at first, right? Wildlife as property owners, how would that work? Would my cat own my front yard? Would a deer own the forest? But the answer is we already have non-human things that own property. Ships can own property. Corporations can own property. People who are not able to advocate for their own interests can own property. And over time, we have expanded and contracted the categorizations of people and entities that are able to own property. And I am merely advocating for expanding that once again to allow wildlife to own property and trust. And so in essence, the core of the proposal that I'll discuss today and that's contained in the book is this. Wildlife can own the land they live on in trust. This does not mean that property is taken from anyone. This is not a reduction in the property rights of existing landowners. And I think that's a really crucial point. This is not a redistribution in the sense that we are taking from existing landowners and giving to wildlife. Instead, what we are doing is essentially allowing landowners to sell property to wildlife trusts, where interested wildlife conservationists, sportsmen's groups, and others can purchase the land for the animals to live on. Now, this may sound a bit wild. How would we manage it? How would it be bought or sold? Would the animals themselves make decisions? But the details are actually relatively well established already in trust law. This incredibly well-developed area of law that discusses things like fiduciary interests and has a well-developed set of common law principles undergirding a system in which we essentially accept that human trustees can make decisions on behalf of people and entities that cannot make decisions for themselves. And I'll talk a bit more later about how that model might work specifically, but the core idea is this. Wildlife trust would operate at an ecosystem level. It would not exist for any single animal within the given area, but instead would be about balancing the different animal interests, including human interests, within a specified geographic area. And it would operate within our system of property such that the lots would be bought and sold by animal owners, just as they would be by any other owner, a REIT, a corporation, a trust that didn't belong to wildlife. So what I'm essentially saying is the mistake that we made as an American system of government several hundred years ago was we assumed something that indigenous people did not, which is in importing English common law, we assumed that animals did not have a right to own property. So in nature, of course, animals coexist with humans in shared geographical space. But in law, we created an artificial system in which humans alone can own. And at that moment, we put a nail in the coffin of wildlife. And we began pounding very slowly over time as animals began to decrease. And the reason they decreased is human populations grew and spread over time, such that animals were gradually pushed off of each individual piece of land. And the solution to that, to my mind, cannot be a federal statute or federal statutes alone, right? Because that requires the diminishment of individual property holders' rights, such that the public has expressed an unwillingness to accept further diminishment through federal statute. So given the political realities of the situation, the answer to this property problem rests in property law itself. And that's expanding the right to own to animals and other living things as well. And so the idea is essentially this: we are taking a system that artificially excluded wildlife and other living things and incorporating them back in. Rather than getting rid of the institution of property, we are expanding it to incorporate the biological reality that humans own and share property with every other living thing. So that is essentially, in a nutshell, the idea of what I'm presenting today. And I look forward to talking about some of the details of the proposal. I'm going to explain existing animal law, talk a bit more about biodiversity law, provide the roadmap for how these trusts could be established and monitored, and then relate my proposal to the rights of nature, a similar movement that essentially overlaps in some interesting ways. But before I do that, I want to pause for a second and situate this in the context of today's lecture, which of course, this is the Stegner Young Scholar lecture. And Wallace Stegner is an interesting, fascinating figure who spoke about the American West. And when I was informed that I received the award and had the opportunity to give this lecture, I was also at the start of sabbatical, and shortly thereafter took a road trip to Moab, Utah. And Moab has a fantastic bookstore, which had virtually all of Wallace Stegner's many, many books available in used copies. And I think I somewhat surprised the bookstore owner when I bought a copy of every one of the many titles that he had in person in the store. And I enjoyed a sabbatical spent reading virtually all of Wallace Stegner's work, or at least that was available in the bookstore. And not only reading his work, but also coming across countless newspaper clippings and notes in the margins from anonymous readers of these works. And the overarching theme of Wallace Stegner's work, if I may, a Pulitzer Prize-winning author with tremendous influence in the American West, is that people are a product of where they're from and our stories matter. He teaches that these stories matter for environmental ends as well. And so in honor of Wallace Stegner and in appreciation for this award, I'm going to take a bit of a departure from the normal legal talk and tell a story that I hope and think might relate to this unusual way of looking at property. So in the summer before I went to law school, I went backpacking with my friend Jake through the Trinity Alps. And the Trinity Alps are this wild region in Northern California. And we hiked for 3 days before we got to the tiny alpine lake where Jake suggested we camp. And when we camped, I was surprised because he suggested that we go fishing on the lake for dinner. And of course, all we had were tents and sleeping bags. I said, when are we going to go into the river fishing? And Jake walked through the woods and emerged a few minutes later with this old green canoe. And I thought, where did you find that canoe? And he told me the story as we floated in the canoe and fished for the trout that we would eat for dinner. When Jake was a boy, roughly 20 years before we went on this backpacking trip, his grandfather called all the members of his family together to have a week-long backpacking trip through the Alps. And when they got there, they were surprised to see that in the back of the grandfather's truck was this green canoe, which was already old 20 years before we were using it. And much to the chagrin of the people who had to carry it for days over the 21 miles between the grandfather's truck and the lake where he expected the family to camp for the week, they had to carry this canoe. And they were sweating and they were cursing, but they didn't complain because the grandfather was the patriarch of the family. And so Jake and his family enjoyed the canoe. The boys fished from it. The girls jumped into the lake. They have these priceless family memories of their entire family gathered together at that lake. And at the end of the week of camping, the grandfather decided to leave the canoe behind. And so he left the canoe in the trees by the edge of the lake, and it became a family secret. Any member of the family who knew where it was hidden among the trees could go to use the canoe. And in this way, a poor man who could not afford a vacation home created a physical tether between his family, the memories they had in that moment, and the canoe that could bring them back anytime to this particular place. And so just as Jake and I used that canoe that week when we were camping in the Trinity Alps, so too could any member of the family at any time use the canoe. And I'll admit, when I was hiking through the Alps in the week to come, I thought about that canoe so many times. I thought about the wisdom of this man, the grandfather I'd never met, and putting this canoe far in the distance in a place where people wouldn't even think to look. But in doing so, creating something so special for his family. And I began to really sort of idolize this grandfather. One day, Jake and I were having lunch and we were sitting on the hillside. There were wildflowers. There was a hill in the distance. The Alps are just beautiful in the summer. And it was really at its finest in this moment. And suddenly Jake said, look, and he pointed to the hillside. And it took me a minute, but I saw a deer. And I said, how did you find that? I could never have seen that deer. And I've been looking at deer my whole life with my father as he hunted. How did you see that deer? And he taught me a trick that his grandfather had taught him when he was a boy. And he said, you have to let your eyes go soft. And if you let your eyes go really soft and become receivers rather than seers, you can see the whole hillside at once. And so I tried it. I played around with it. And I began to see what he was saying. If you make your eyes go soft and less focused, you can take in the whole hillside at once and then see the entire landscape, and anything that moves on it will jump out at you. So instead of looking at individual points or brushes or trees, as my father had taught me to do, you instead took in very passively the whole hillside, but were able to see any movement anywhere in this broader landscape. The night Jake showed me it works for stars too, and it's something I still do. I've taught my daughter this trick. If you're laying on your back looking up at the night sky, in the past, prior to learning this, I would only see the individual stars or maybe the individual constellations. But if you allow your eyes to go soft, if you let things become a little bit fuzzy, you can see the whole night sky at once. Suddenly, the interrelationships between the constellations become clear. You see a bigger picture than you can otherwise see. Now, Jake's grandfather, through Jake, taught me about this second way of seeing. It's a different way of looking at the landscape. I had always thought I knew how to see. I thought there was one way to see. And in this moment, a man with a high school education taught me what his grandfather with an 8th grade education had taught him, which is a second way of seeing. And over time, as I've gone on to law school and then a legal career, I began to understand that the second way of seeing is not only when you look at nature, but you can also look at law in a different way. And when you begin to look at law in a different way, and particularly for our purposes today, property law, you can understand that there's a much broader picture than what we look at generally. When we talk about doctrines, age-old doctrines, things that are traceable to centuries ago, traveling from Vatican law to English common law to US law today, we can look at the individual doctrines, or we can talk about particular cases. Maybe we consider the field of property law as a whole. But too often we look narrowly as if we're looking at a star in the sky or maybe a constellation. And it's really time, I think, to begin to remove that artificial divide, to allow our eyes to go a little softer and look at the whole landscape. And when we do that as it relates to property law, it becomes clear that what we've done over time is artificially dissect the biophysical reality of land and resources and people and wildlife and segment them into these different academic fields. We have natural resources law, which talks about the resources that run with the property. We have environmental law, which essentially talks about the pollution control that people issue into the air or waterways. We, of course, have we, of course, have property law, the field itself, which is largely about the sale, purchase, and transfer of land. We have land use law, which is about the restrictions of land. And we have what is called, at least at Arizona State University, Indian Law 2, which is essentially indigenous natural resources. We also have animal law, a field which is about the treatment of animal, and increasingly biodiversity law, which thinks about living things in ecosystems. And so when you think about these disparate areas of law, and I could name many more, I believe Robin teaches ocean law. I understand that there are some seminars in wildfire law now. When we think about these disparate fields, it's like looking at the constellations in the sky. But by dividing off these different sections as if there's something that can be separated, we, or at least I, am sometimes guilty of tricking myself into thinking that I'm seeing the whole picture, when in fact, with softer eyes, you see that the picture is much broader. And if you look at these fields collectively, the legal treatment of humans' relationship with land and with one another over geophysical space and the use of resources, a different picture becomes clear, right? It's as if we talk about property as this bundle of sticks, right? And we think that we know all there is to know about property when we talk about the different sticks and the bundles and the different parts in this very common legal analogy. And we just focus on that bundle. But if you stop for a moment and look beyond the bundle, if your eyes became soft, if you took in the bigger picture, what might you see? And I often think of this analogy with a bundle of sticks and us talking about property in this limited way, and then understand that behind that bundle is the whole forest, right? So this hand is holding a bundle of sticks, and in the forest behind are the trees that were cut and fallen, the branches that were lobbed off and then stripped and peeled, and all of the aftermath, the animals that lived in that forest. And the remaining pieces that are stripped, these little branches, these little twigs, are thought to be the whole picture, when in fact they exist in this rich biophysical context that we do not fail to consider because we look so narrowly just at this human-created institution of property. So if we accept this understanding, if we accept that the institution of property is doing something to trick us, to make us look too narrowly at a field that is in fact describing something much richer and much broader, the question becomes, what do we do? And there are essentially two responses. You hear them both in conversation today. So one response is, let's keep it as it is. Let's press forward. Let's continue with progress. Let's focus on the economic development alone, right? Or you hear increasingly calls for, let's just get rid of the institution of property is all. You hear people say things like, property is evil, property is bad, property is the root of the problem. But I think the answer is probably somewhere in between. I know very few people who don't care at all about nature or wildlife. I think most people believe that it's important for varying reasons to different people. But I understand that people in both those rural and urban contexts, the two worlds between which I split my time, have very different understandings and conceptions of the importance of property and wildlife, and yet most believe it matters. So if you believe that wildlife matters, right, but you also think there are other values that might matter as well, what do you do with this institution of property that has systemically excluded wildlife and other natural interests, essentially chopping them off of the field and talking about land as if the creatures that live on it do not exist? What do you do in that case? And the answer, I think, is not to get rid of property. That seems messy and time-consuming and unnecessarily difficult to me. I think the much easier answer is to fold wildlife into the institution of property. I said that generations ago, judges and scholars artificially divided property so that it became this human-only institution. And if we simply bring animals back into it, then we can accomplish many of the things that property law has unintentionally done. which is allow each individual landowner, not only allow, but incentivize each individual landowner to gradually, over time, as land and resources become more valuable, to push wildlife off of property, such that wildlife that used to be dispersed across the American landscape is increasingly confined to public lands. And unintentionally, public lands have become essentially zoos for wildlife, these large outdoor protected spaces, whereas private property is increasingly less available because of population and resource pressures. But this puts pressure, as Utah knows particularly well, on the dimensions of state and federal and local interests, right? And so one of the ways to overcome this is through the federal approach, which is largely what we've seen through conservation thus far. But the other option is through a private approach. And I don't think they're mutually exclusive. I think they're absolutely complementary. But the potential for private property rights to extend to animal as a mechanism to preserve habitat and thus biodiversity, I think is crucial. And part of the reason that we haven't landed on that approach is because of this lopping off of property and natural things into different legal fields. But when we take a step back and we look more broadly, we can see that animal law only partially addresses this concern, right? Many of the people who are ardent animal activists, animal rights activists, don't consider wildlife to be the most pressing of their concerns. So animal rights started in its modern form in essentially the 1970s with Peter Singer and other writers who were advocating for extending some degree of human-like rights to certain animals based upon their capacity. So, for example, chimpanzees in cages or orcas in small aquarium facilities should be freed and allowed to live lives, or at least put into conditions that are cognizant of them as sentient beings, right? And the arguments for this go along human dimensions to say these animals are sufficiently human-like. They experience enough compassion and empathy and intelligence that they should be folded into our rights system of law. But animal rights alone doesn't address wildlife, because many wildlife species that we know as a scientific matter are absolutely essential to the ecosystem, to the broader functioning of the natural world, aren't very high on the so-called tree of life, right? So if we think of animal species with humans at the top and other creatures going down the chain according to how established they are, how human-like they are, you sort of can get to potentially creatures like chimpanzees and monkeys through this animal rights approach. But as you fall farther down the chain to things like insects or reptiles or rodents, there's virtually no way to bridge the gap from a sentience human-like argument. And yet wildlife advocates, which I consider myself to be a wildlife advocate, but I also consider many people of many different political views, geographic positions, etc., to be wildlife advocates. Wildlife advocates understand that reptiles and rodents and fish and insects are as much a part of the natural world as these more sentient beings, right? And so the animal rights movement systemically misses these creatures, right? They focus on fur and factory farming and animals in captivity, all of which are important. But my argument in this book and elsewhere is essentially that we are equally culpable for what we do to wildlife. We know at this point scientifically that the systemic use of property and resources for human uses at the cost of wildlife without protections is akin to killing animals, right? The destruction of habitat, the conversion of the habitat, the development of wildlife habitat gradually over time will lead to the diminishment of wildlife. And if we have any questions, we need only think about the statistics I provided at the beginning, right? 4% of the biomass on Earth of mammal species are wildlife. 4%. We've taken 96% of the biomass of mammals on Earth for humans and human-owned livestock. We're taking more than our share. And so a solution, this wildlife property rights solution, which allows for the creation and establishment of habitat exclusive to animals or for the use of animals, it can vary a great deal on a situation by situation basis, essentially resolves this fundamental problem of biodiversity by reintegrating these disparate fields of natural resources and property law and animal law and biodiversity law, and showing that they operate in the real world as a collective whole, and that legal solutions must be cross-cutting and bridge against these ideas. So I will say there are many, many aspects of this proposal. The existing animal law draws on both the biology of animals, which it's my favorite chapter of the book. I will say we won't have time for it today, but it traces how animal species ranging from bees to lions, whales to ants engage in property behavior that we call territoriality, but in fact is remarkably similar to human property behavior, right? They have intergenerational transfer rules. They have the defense of boundaries, nonviolent dispute resolution. So you could say that animal property behavior, animal territoriality on its own, might provide one legal basis on which we could argue this common law property approach already exists. The other basis is the indigenous conception of property rights that pre-existed the imposition of English common law. And as a matter of customary law, this very old concept in property, and part of why I love property is old concepts still matter in this common law tradition. Common law approaches might indicate that a customary approach to wildlife interests in the United States would suggest that indigenous practices afforded wildlife interests to animal, and because they were never explicitly diminished or denied by the courts, they still exist today. Right? So that's another way that we could get there. And those are sort of two legal pathways. But if we buy those foundational underlying arguments, and we think that in fact we should extend human property rights to animals, what do we have to do? Right? We're largely a group of lawyers. We understand there are different legal pathways to get to ultimate goals. Do we need to pass a statute? No. It would be nice, but it is not required. There is sufficient precedent to establish that animals can own property. The majority of American states in the past 10 years have adopted a form of the Uniform Model Probate Code, which allows animals to inherit from human owners and to receive property and trusts. So in the majority of states in the US today, there is an existing statutory state law that allows the establishment of wildlife trusts. So we don't need a statutory approach. The argument might be we need a litigation-based approach to establish these trusts in a way that this Ninth Circuit case law has gradually been establishing that animals can independently sue in court, but it's not strictly necessary. In fact, one of the sort of interesting aspects of this proposal is it doesn't require a government response or government action to begin. In fact, individuals can begin with trusts today to start wildlife trusts. Now, of course, they should consult their lawyer. I'm not providing legal advice or encouraging anyone to begin a trust on their own, but there is sufficient precedent and existing law that indicates that these trusts are already allowed. So one of the beautiful aspects of this approach is you're not waiting for a particular political party or statutory process to unfold. It's something that individuals who are sufficiently concerned, whether it's sportsmen's group or conservation groups, can begin today. And it mirrors in many ways conservation easements and other forms of conservation-based land holdings, but it's specifically for animals. And in that way, it is different because it makes undeniable the fiduciary interest to animals specifically, right? So how do these trusts operate? Well, as I mentioned earlier, we have trust law, we have fiduciary duties. Trustees would likely perform scientific and sociological analysis to understand the inner workings of science and animal life, plant species, and human needs within a particular area to form trusts. I personally would also like to envision an overarching model, a private governance model across different trusts that would be a best practices system evolving over time, through which this model, this certifying regime, could certify trusts as being in compliance. We have a lot of experience with that in natural resource context, and the private governance coupled with this overarching public governance system, right? The traditional trust law provides strong protections for animals while also providing the flexibility that trusts will need to navigate this relatively new landscape. So the final question is, how does this conservation measure fit into the rights of nature? And the answer is better than you might think. You might have heard of the rights of nature. It's the idea that natural objects have legal rights, but the ways in which it's happened and unfolded over time are highly disparate. Christopher Stone is the legal writer who gave voice to this idea, although of course it's existed in indigenous cultures worldwide since time immemorial, that humans are not alone in having rights and that nature might have rights as well. And increasingly throughout the world, it's taken a variety of forms. Stone recommends that legal standing, the right to sue for damages, and the application of damages to the needs of nature are sufficient for rights of nature. In other countries, and also with tribal governance in the United States, you see instead that either legal personhood is assigned to a natural object, such as the Klamath River, which was decreed legal personhood or granted legal personhood by the UROC in California, or a variety of examples in Australia and New Zealand for various resources. You can also have constitutional provisions, as with Ecuador and Bolivia, creating a constitutional right for nature. And in fact, I think that the rights of nature approach is coming under critique by modern American legal scholars. That's sort of the wave of scholarship I'm seeing. But I think it's because we haven't fully fleshed out what that meant. And one aspect of the rights of nature could be wildlife property ownership. And this could extend in many ways. Virtually all of the arguments I make on behalf of wildlife could also extend to plants and, in fact, any other living thing. And so, in essence, wildlife as property rights fits sort of this missing piece, right, in the existing legal landscape. It's a private governance solution. It is a property-based solution, as opposed to federal or state statutory solutions, or constitutional or international solutions that allow individuals to express their preference for wildlife conservation by buying, donating, and creating trusts for the continued nature of animals. So with that, sort of briefly encapsulating a book-length idea with cognizance that we have questions that I really want to get to, I will just summarize by saying that increasingly, particularly with COVID and the variety of things that have happened in the past year, I found myself thinking about this canoe. And it's funny because when I walked out of the Alps, I carried with me a rock, a granite rock from the Trinity Alps that I picked up. And it has been kicking around in the bottom of boxes as I moved to Chicago and Mississippi and Manhattan and finally Phoenix. But it sits on my desk today. And as I began thinking about this lecture, and as I began thinking about the man for which it was named and the stories that are important and meaningful to me, I began to think again about this idea of the old green canoe in the middle of the Trinity Alps. And somehow it gives me great, great comfort to know that this canoe is sitting there. And I imagine the comfort that it must give Jake and his family to have this physical connection, this place in the world. So many of us have it. I have a town that my family's lived in for 5 generations. But in these connections, in these physical connections to the land, we can also think about connections we can make for our students and ourselves and future generations in the law. And so I like to think with property law and biodiversity law of leaving canoes in the minds of my students, of leaving a tethered place to which they can come back. Maybe they're not using it today, but they'll always know that it's there. And to some degree, that's what I'm trying to do with wildlife as property owners. To be honest, I don't have a strong sense of the way in which this idea will be received in the immediate future, but I understand that by planting the concept that property law made a mistake, that mistake is driving biodiversity loss, and that biodiversity loss can cause the end of humankind, in addition to destruction of the natural world, that we might happen upon a solution or have in our minds a solution that can solve this problem. So with that, I am incredibly thankful for your time and also looking forward to your questions.
Karen, thank you for that extraordinarily expansive, enlightening, and challenging lecture. I think you've expanded our minds in the best tradition, both of Wallace Stegner and of the Young Scholar Lecture here at the Stegner Center. And for that, we're greatly appreciative. I forgot to mention in my introduction that we'd have an opportunity for questions. A number of you have spotted that. But if you have questions, the Q&A button at the bottom of the Zoom screen is available. You also have the opportunity to give a thumbs up to particular questions that have already appeared. I'll just go ahead and begin working through the questions. And we'll continue till 1:30 at the latest. But we've got a number of questions, as you might imagine. So let me just jump on them. The first one, excuse me, relates to hunting. and it asks, how would your proposal affect hunting laws and the possible non-application of Pittman-Robertson Act funds to private trust lands that you're advocating, if I understand the question correctly?
Great, fantastic question. So I will admit, the first time I presented this idea, it was to an animal law, animal rights conference group, and they were shocked and somewhat horrified at my answer. So I will preface it with saying this may be shocking to some that are particularly aligned with animal rights, but my proposal does not actually affect hunting at all. In fact, hunting could occur in my proposal on the animal-owned or wildlife-owned trust if the particular trust allowed for that model. So when I say this is truly a bipartisan proposal, it is. One of the sort of ways to think about this is people at both ends of the political spectrum are actually very interested in wildlife. Sportsmen's groups are some of the largest contributors to wildlife conservation efforts in the United States. And this trust model can actually work in tandem with that. It would not, in my mind, prohibit hunting. Now, of course, if a conservation trust wanted to establish a private trust that had language excluding human uses, including hunting, they could do that, right? Trust law is infinitely variable, and that's one of the benefits to it. Just as you could write in or out a particular child in your will, so too could these trusts include or exclude hunting. But there is nothing in the model itself that would discourage or prevent hunting.
And that leads me to a question. I'll go ahead and interject here, and that is, so if a trust is set up, could it be set up, for example, to focus on, give priority to animals that are hunted, elk, deer, etc., or would it be necessary to include the whole ecosystem, which you talked about early on?
So that's a great question. Was there more of the question, Bob? Sorry, I was so enthusiastic about it. I dove right in.
Yeah, individual animals versus the entire ecosystem as the focal point of the trust.
I think that's a fantastic question. And the interesting thing is, we in fact have, as a matter of federal law and state law, existing animal property rights already. And you see that they operate in many cases in both ways. So for example, I argue in the book that 200 million acres of US lands are already implicitly operated in some degree for wildlife interests. And those operations vary tremendously from BLM lands to National Forest Service lands. In some examples, I believe it's the prior horses in Montana, there is a particular horse species that has 30,000 acres set aside in federally protected land just for this particular species of horses. But of course, on other lands, wildlife are one of many interests, or wildlife at an ecosystem level are protected. And so, of course, that's a matter of federal public lands, but I imagine that in the private context, you could have similar variations. I think that you would have certifying bodies that might make rules about sort of whether it was an ecosystem or species specific land, and that certification or ongoing certification with the trust model might require more of an eco-based system. But you can imagine a situation in which trust lands could be established for any variety of uses, including exclusively sportsman species, like you mentioned, like elk, deer, etc.
Okay, thank you. Another question, doesn't a recognition of property rights in non-humans presuppose the existence of ownership in things that are held in common by all, such as water, functioning ecosystems, a hospitable climate, that sort of thing?
This is interesting. So one of the concepts that this idea runs into is the public trust doctrine, which is the idea that there are certain resources so valuable that they in fact belong to everyone collectively, although individual owners may have certain rights to portions of them. So for example, the California coastline, you can technically walk along the entire California coastline beyond the low tide mark. And there's also a coastal trail. And this is because of public trust law, right? This is the idea that everyone has access to the coastline. And there are other resources and other examples in law of these public trust resources to which we all have some degree of interest. You could also say that this isn't even the public trust doctrine. This is just a matter of natural law. There are certain things to which we all have a right, if you will, even if not explicitly legally defined, such as the right to breathe air. My colleague Rhett Larson talks about rights to water and whether water is alienable or not, given that we all need water to survive. So I think there's an interesting question about, well, if we're giving animals rights to property resources, you could do it either to a specific area of land, or perhaps you could say there's a right to a resource that overlaps many sections of land, such as airways for birds, like the Migratory Bird Treaty might suggest that there are existing property type rights to various resources. And I think this is a good opportunity to not only think about animal rights, but also rethink about our system of property and if there are common rights to which we each have an interest. So the most common sort of example, and the most recent example of this, is in Europe, England specifically. They recently reworked property rights to introduce something like the Freeman's Law in Scandinavia. So in England, 20 years ago, people had no right to walk through an open field that they didn't own. And today they do, subject to certain conditions. And so you can see rights being reworked and redefined over time to incorporate more or less exclusion of other people, or in this context, other animals. And I think explicitly having those conversations about what can be individually owned and what cannot is probably a national conversation we're going to see more of in the future.
Thank you. Very helpful. Related to that, there's a question. It begins with a great concept, Karen. How does the idea of landowners giving animals trust rights in their land work to support wildlife corridors that are so important to healthy populations?
Great. So wildlife corridors, just in case there are folks who aren't as familiar with it, is the concept that certain migratory species, both on land and also in the air, requires contiguous parcels of land. So essentially roadways, or what Richard Epstein would call a long and skinny path across which to travel to accomplish their migration routes. And these historically have been thought of as fixed route. For example, this species migrates in this particular pattern over time. But increasingly, people are observing that the routes shift in time to varying natural resource and climatic conditions, such that corridors are constantly shifting. And one of the interesting and important things about wildlife corridors is that the use of individual private land parcels can block a corridor that is essential for the migration pattern and thus the continued existence of a species. So I think that private property rights for animals, or wildlife owned rights, can be essential in providing uninterrupted corridors of wildlife migration. So if there was a species or species in which conservation groups or sportsmen were particularly concerned, they might then buy small pieces of land to assemble a long and skinny corridor through which the animals could safely migrate. So we think of long and skinny resources like railroads, rivers, roadways, pipelines, power lines, these very long things that have to cross hundreds, if not thousands, of individual land boundaries. And traditionally, we have the government use eminent domain to get permission from each of the owners, any one of whom might otherwise hold up the project. It's difficult to think of eminent domain being used for private property rights, but certainly individuals could assemble these parcels of migration corridors to protect species. So I think that would be one of the more innovative ways that concerned conservationists could contribute to species.
Might the government also have an opportunity to employ its eminent domain power to create the wildlife corridor, just as it does for pipelines?
Absolutely. And I think that would absolutely be the most effective way as well. We can imagine, much like the Wilderness Act designation, that there might be an overlay on federal public lands that would be a wildlife protection overlay. And in that way, existing public lands could be used for wildlife interests, such that, for example, a habitat corridor could be assembled through the use of eminent domain, if necessary, to connect non-contiguous parcels of public land.
Great, thank you. So another question, in further expanding the institution of property to encompass wildlife as property owners, does this pose a substantial risk from the social norm perspective of further commodifying ecosystems, making it even harder for society to shift toward biophilia?
Yes. So this buys in to the system of property and capitalism as it exists. So if one wanted to take the position that property or capitalism are inherently contrary to the interests of nature and wildlife and should no longer exist, then one could say we should get rid of the institution of property altogether and instead only focus on solutions that are larger in scope and seek to overturn existing institutions of property and government. That is an alternative to this position, and it's one that I think some people are making. It's not my argument. I say let's work within existing institutions and governments and fold animals in. But if you are someone who believes that the commodification of land and resources is inherently in conflict with the natural order or the way that things should be, this proposal would not work. Now, I will say, and I think this is an important point, one of the things that led me to be comfortable with this proposal was the observation in the book, which I didn't have time to get into today, that animals themselves operate systems of property. And so through the reading and understanding of hundreds of scientific articles, I came to understand, at least in my mind, that territorial behavior in animals and property behavior in humans are remarkably similar. And that lessened some of the hostility that I've seen around property or towards property and allowed me to reconsider the idea that maybe property is not inherently suspect. Perhaps it's naturally occurring. Perhaps it's the way we're using property to exclude in unnatural ways that is the problem. So if you find yourself critical or skeptical of a proposal that relies on property law, I'd at least encourage you to read chapter 3 of the book, which talks about animals' use of property, which presents an alternative vision of property as the way that people and other living things can share resources instead of strip or commodify resources.
Great, thank you. So another question asks, how's your proposal different to what land trusts do in purchasing or accepting conservation easements? Natural wildlife habitat is a standard conservation value.
Absolutely. So one of the really interesting things of conservation easements is they often can incorporate aspects that protect habitat, or in some cases, specific biological resources, which is to say certain named animal or plant species that must be protected in the conservation easement. I think of conservation easements as complementary to animal trusts, wildlife trusts. I think that they are a different mechanism of achieving shared goals, but I think that they are in some ways distinct. Much like the multi-use mandate of Bureau of Land Management lands and some other federal government lands requires the competing or balancing of different concerns for the management of federal public lands, so too must conservation easement trust administrators balance different aspects of the conservation easement, some of which may include things that are antithetical to the conservation of animal or wildlife or living things on that property, right? And so this balancing act between many different competing resource uses exists within most conservation easements that I've seen, whereas the Wildlife Trust explicitly favors the living things on the property, right? So it creates a different set of protection, and the fiduciary interest runs more specifically to the biodiversity goals specific to sort of preservation ideas. So I would say that the biological aspects that are standard in many wildlife or land trusts or conservation easements on land are in some ways a model for wildlife trusts, but wildlife trusts are more protective than I would say the average conservation easement.
Gotcha. Would, on a wildlife trust, would one be precluded from constructing a cabin or a lodge or something like that? Would that be permissible?
That's a great question. I think the answer, as is the frustrating answer from so many law professors, is it depends. I think it depends a lot on the context. the way in which the individual trust is formed, the way in which the lodge or cabin would be used, and the way that the trust administrators over time, against the backdrop of the court, think that the trust might use the land. I will say that I personally am interested in creating a wildlife trust on the front of my 1 acre parcel of land with the house at the back of it. And the house would exist, right? It would be part of the same landscape, although not part of the trust land itself. So one of the fun things about property is that it is so creative and adaptable to individual situations that one can imagine virtually any situation sort of playing out in the trust context. It's really just a matter of sculpting the trust, the trustees, the stated interests, et cetera, in a way that makes sense. So the answer is basically no. I can imagine a situation in which this would not be precluded, and you could have a trust or cabin in a parcel or series of parcels that are largely devoted to wildlife property.
And you could even have a canoe, I assume.
You could have a canoe as well. That's a great point.
Okay. So another question asks that what are your thoughts on how the model you described could be used to reimagine or redesign federal reservations like national monuments?
Yes. I think
national monuments are back in the news here in Utah after what appears to be the conclusion of the recent election.
I would say they've never left the news in Arizona. Bears ears is a constant. I'm sure it is in your class as well, Bob, a constant theme and subject of interest for our students. I saw a presentation in natural resources just the other day. So I think one of the interesting things about federal public lands and public lands, state public lands as well, is that they have in essence become wildlife reserves in many places. The reason we don't have worse biodiversity loss, the reason it's not more evident, is because of this roughly 1/3 of the United States that's held by the federal government. And so one of the questions is, how would this intersect with property trust for wildlife? One option or one thing that could occur is that the wildlife interest would become increasingly privatized. There's this American Prairie Land Project that plans to make essentially the largest national park in the United States, but wholly private. So it would not be publicly held, it would not be government-owned land. And one can imagine a scenario in which wildlife trusts create private land holdings for the use of land, animals or wildlife that are divorced from or separate from public lands. One can even imagine, amid proposals for divestiture, right, the sale of public lands or the gift of public lands from the federal government to states and then potentially on to private landowners, that wildlife trusts might be a participant in the divestiture process. I think that's not where we are politically today. I think that may become more of a question in the decades ahead. I think the more interesting and more immediate question is, can we imagine a situation in which a private trust responsibility, somewhat akin to the public trust doctrine, overlays existing federal public lands for wildlife interests? And I think the answer to that is yes. We have hundreds of millions of lands that are subject already to some animal interests at the will of Congress, and expanding and formalizing that seems entirely possible to me.
That, I assume, on the public lands would take an act of Congress in one form or another.
I think that's right. I think the existing measures have happened in this very piecemeal way with the organic acts of different agencies and then the changing statutes over time that incorporate animal interests. I think the easiest model would be something like the Wilderness Act, but specifically for animals. So an overlay across different designations of federal lands that might be protective of animal interests. But I would love your thoughts on that sometime, Bob.
So how do you overcome the barriers posed by anthropocentrism to implement your ideas?
Yes, I think this is a great question. So anthropocentrism is the idea that humans are at the center of the universe, right? And so there is a conception, I would say, in mainstream modern American society that is an assumed norm whereby humans are at the center of essentially everything. Certainly our legal institutions, there's institutionalized speciesism, where we sort of just assume that human interests and needs are those that are most relevant and predominate in virtually every situation, whether explicitly or not. But also in economic systems and government institutions, of course, we're very centered on human needs. I think my understanding, though, is it doesn't have to be this way. And many of the bases that we point to suggest that it has to be this way, in fact, are not historically accurate. So you have many examples in existing US indigenous cultures that have held since time immemorial and continue to hold today that humans operate as part of a greater whole. And that's recognized in a variety of ways where human uses are allowed. But they occur with a cognizance of the importance of other things, of other beings, of a living world, et cetera. Now, obviously, there's huge diversity within tribal traditions. In the Utah Law Review article, I cite a few indigenous scholars who talk about these worldviews. If you haven't read it, I cannot recommend enough Braiding Sweetgrass by Robin Wall Kimmerer, who discusses the sort of intersection of scientific and indigenous perspectives. That's one model for understanding what an alternative worldview might look like. One model, which is comprised of countless variations among tribes, which can differ quite sharply. But we also have other models. So in many religions around the world, Jainism being perhaps at the forefront, humans are so responsible to animals that in fact we should constrain our actions to an uncomfortable degree just to avoid disturbing animals. In Buddhism, there is deep respect for animals, such that Buddhists are traditionally vegetarian, although that's not necessarily or strictly the case. And then in the Christian religion, the Judeo-Christian texts actually support a different view of wildlife than is sort of the predominant mainstream American view, one that encourages that the fate of humans and animals of all kind are intertwined, right? That we are codependent and interconnected with animals. And then also that humans should observe animals for the ways in which we interact with the natural world. And so there are other religious traditions, I cite some of them in the Utah Law Review article, that argue that maybe we've had this wrong, right? Maybe we think that humans are sort of the center of the world and it's always been that way, but maybe that's actually a relatively recent innovation in both religion, certainly in scientific understandings, and then also in legal understandings. So I think what I'm arguing for a bigger picture is a legal system that reflects what people believe a bit more. That is not this ideologically distant, removed thing that operates separately from what we as human beings and a biological living sphere understand, but is in fact more integrated and aligned with what many of us believe at our core, and what sort of the worldview that we hold in our hearts perhaps should be reflected a bit more in our legal system.
Thank you. We're almost out of time. Let me throw two short questions at you. One, how are the fiduciary duties of trustees enforced when the beneficiaries are animals or plants? And then what's the business model for a wildlife trust? How do you get the money to make it work?
Great. So the fiduciary duties would require a legal enforcement on behalf of the animals, which requires money, of course. So the establishment of the trust can learn from the rules of conservation easement and the lived experience of conservation easement. Buzz Thompson, Jessica Owley, and a group of other scholars have done tremendous work on conservation easement. And we have essentially decades of learned history of this new tool being invented, which is somewhat akin to wildlife trusts, and the lived experiences of the things that went well with the implementation of conservation and what went poorly. And one of the lessons that we can take from that model is the idea that you have to have someone as an enforcer, as a voice for the trust in case something goes wrong. So essentially a private right of action for the trust by concerned conservation groups over time might be one way to make sure that animal interests and wildlife interests are being advocated for properly if the fiduciary duty is being violated. And then secondarily, in addition to this, you can have this private certifying body, which would allow a more uniform non-judicial treatment of best practices and standards. Finally, the business model, it's a great question. There are endless details that could go into this, but again, we have some data, particularly in the form of land trusts, conservation easements, the work of the Nature Conservancy, that shows that there is both the money the expertise and the interest to do things to protect nature using traditional tools of property. So these economic tools can be used in ways that benefit nature, and some of those models can be borrowed from the land trust context. So that it's not just sort of philanthropic giving in the way that we see in some underfunded, for example, animal rescue organizations. It's actually an economic model that takes into account various resources on the land, some of which might be really economically valuable. Great questions.
Very helpful. That's a great note to end on. It gives us an upbeat notion that perhaps we could see something like this implemented on the land in the not too distant future. Very thoughtful presentation, extremely provocative idea, Karen. We're most grateful that you joined the Wallace Stegner Center as our 16th annual Young Scholar. I will, on behalf of the various attendees, applaud your presentation and your question and answer session. Let me simply conclude today by reminding folks that we will be back with green bag presentations next semester. Information about those presentations is available on the Stegner Center website. It includes Rebisoning the West, the Colorado River Basin Reimagined, and the use of executive authority for conservation purposes. Also, our annual symposium in mid-March on the plastics paradox is scheduled for next semester. Again, let me thank Professor Bradshaw. Let me thank the team here at the College of Law and the Stegner Center for their technical support and the rest of the support that has been provided. And thank you again for joining us today. We will see you next semester. Thank you again, Karen.
Thank you.